SJC-12752 in the matter of an impounded case.
Menken, good morning.
Good morning. I'm Attorney Michelle Menken, arguing on behalf of the juvenile this morning. May it please the court. We're here today because a constellation of footnotes in this court's decisions,
Darn footnotes.
Porges and Mogilinsky 1 and Mogilinsky 2, observed the potential for misuse of General Laws, Chapter 119, Section 72A, and cautioned the Commonwealth that delay is to be avoided, and opined that the Commonwealth bears a burden to justify delay in its 72A case. And so here we are in a case of inordinate delay in proceeding against someone who is now an adult who had a car accident when she was 17 years old, a tragic event, but one that bears all the earmarks of juvenile misconduct. And we're asking the court for guidance on when and how the accused can put the Commonwealth to its burden, and how the Commonwealth's burden is discharged, and when and how the juvenile can be heard in vindication.
Can I ask you a question? I'm so confused. I thought maybe the Commonwealth was basically saying it could be done pre-arraignment as part of the second prong of the juvenile court judge. What do you think about that? Is that right? Did I get that wrong?
I think what I read the Commonwealth to be saying was that it shouldn't happen pre-arraignment, but that it should happen as part of the second prong at the post-arraignment 72A hearing. And of course, in this case, that's not a possibility. And our position is that the motion can be heard prior to arraignment and should be heard consistent with what's now a fairly common juvenile court practice to fully resolve these kinds of dispositive motions.
But Justice Lenk's point is well taken. Before the case could ever get to Superior Court, the issue of any prosecutorial delay and the reasons for it would be fully vetted in the juvenile court transfer hearing.
So there's the issue of the due process claim we submit is distinct from the issue of the public interest that's litigated at the 72A hearing. And to be sure, in the Porges footnote, there's an indication that sort of you want to find out first whether this is going to be transferred before you go through the trouble of hearing the motion to dismiss on the prosecutorial delay. And we submit that that's actually upside down. So the question of whether this case is whether jurisdiction is properly invoked under 72A potentially forestalls the need to go through the quite elaborate, what can be a quite elaborate 72A hearing. And the factors, the consideration of the propriety of the invocation of jurisdiction is really distinct from the way that the issue of delay plays into the public interest. So we have a nice description in this court's decision in JH, for example, of what that 72A hearing looks like and what the appropriate considerations are. And of course, delay is going to play into questions of was there really urgency? Has there been time for rehabilitation already? And the length of the delay is going to play into that. But that's distinct from the due process question of whether the juvenile can be hauled into court at all. And if that's resolved first, then you don't have to go through the probable cause hearing, which is similar to a bind-over hearing for bringing a case from district to superior, and as well the interest of justice, which is quite...
So are you saying that there ought to be a hearing first, pre-arraignment regarding the delay?
Yes.
In which the Commonwealth is forced to disclose why it waited so long. And then if the judge thinks, well, that was a pretty good reason as far as I was concerned, then you go on to the 72A hearing, but you still take it into account again on the second prong?
Sure. Of course, the fact that there's been this passage of time is going to come into play.
The fact of delay, not the reason for the delay.
Well, they're going to be intertwined, I would imagine, in several cases. Okay. So,
I mean, help me with this. Why is there ever an arraignment in juvenile court under 72A? It seems as if the only issue for the juvenile court is not to arraign the person, but to determine whether the complaint is dismissed, the delinquency complaint is to be dismissed, and the complaint is to issue in criminal court.
So are you asking why couldn't that entire process take place basically prior to arraignment?
I don't see why any arraignment would ever happen in juvenile court under 72A, because the decision is whether the complaint is dismissed or is to, whether the delinquency complaint is to be dismissed, or whether or not a criminal complaint is to issue. If criminal complaint is to issue, then the arraignment would be in criminal court.
Well, I think procedurally there would have to be an arraignment on the complaint before it was dismissed, but also the question of...
Why? That's not what happens in juvenile court a lot. They often dismiss before the arraignment.
Well, I guess that's true. So I stand corrected on that. I misspoke. But I think there is a problem where the issue is the consideration of the public interest. This court's opinion, that then you do run into an Article 30 problem, I believe, because the juvenile court does not have discretion to dismiss prior to arraignment a valid complaint in the interest of justice.
But isn't the issue, aren't you claiming that a complaint which is unduly delayed is a violation of due process and therefore is not a valid complaint?
Yes, that is my position, and that, again, is distinct from the question of whether the public interest warrants prosecution of this now.
But the cases you're referring to, which I happen to write, didn't address 72A.
No,
those were just
of course not.
usual delinquency cases. They were not 72A hearings.
So, you know, the law is that ordinarily Article 30 would prohibit the juvenile court from making a dismissal in the interest of justice over the Commonwealth's objection. However, when the legislature has conferred authority in the judge to make that kind of a determination, then sure, that could happen prior to
Right, the
arraignment
statute
as well.
expressly permits the judge to do that under 72A.
I'm sorry?
The statute under 72A expressly permits a judge to make that determination.
I agree, and so
So let me just make sure I understand. So do I understand you to say that what should happen at this or any other 72A hearing is, and I guess there's a question of which order, but the judge would need to make a determination of three things. One, probable cause. Second, whether there's a due process violation for undue delay, neither of which are discretionary, both of which would be decisions either of fact or of law. And then thirdly, if you survive the first two, the discretionary decision of whether the case should be discharged or should proceed to a criminal court. Is that your view, that there are three decisions to make?
yes, and I agree with Your Honor that could all absolutely happen prior to arraignment.
Let me ask you on that process. And first of all, let me thank you for people that are listening for the hyperlinks in your brief. They're incredibly helpful. Hint.
Thank you.
But under your analysis, and I fully understand what you're saying about it, the harm being the institution of proceedings, and there's a due process interest, and if there's undue delay, which we said in that footnote. But you make it a mandatory, under your worldview, finding by the judge, as the Chief just laid out, one of those three steps. Why wouldn't we keep the statute as the statute is and allow the juvenile to move, or the judge sua sponte to move for a hearing regarding undue delay? Because oftentimes the delay is readily explainable. The person's in the wind, someone comes forward late, etc. It's not an issue. Just like in Rule 36, if you had it automatically in Superior Court, every case would have a Rule 36 hearing, right? And we don't have that, or due process part of delay. Why should this be special? Why shouldn't we just leave it to the parties to litigate this when it does arise?
Well, I agree with Your Honor, and I think that if a prima facie showing is made by the Commonwealth, for example, in the application for the complaint, saying, you know, the complainant just came forward, we've had no prior contact with her, the delay is easily explained, and then there's not an issue to litigate.
But why should we litigate that?
I don't know that you would need to litigate that in every case.
I guess that's my point, because juvenile court judges, as you well know, are very busy. Why should we give them an extra burden, and the burden should be on the juvenile or the judge if they see something that's amiss to raise that issue and litigate and have evidence if so needed.
I don't think we're that far apart. I mean, I think that our suggestion is that a showing be made by the Commonwealth as part of the institution of the complaint in order to show that this is properly invoked, and that in requiring the burden to be discharged in that way, you actually forestall potentially a litigation, because the defense counsel may look at this, the judge will look at this, it's readily explained, this is not worth sort of an evidentiary hearing.
On the papers here, I mean, this is a good case for you, because on the papers here, it's a mystery, right?
That's correct. We know that the Commonwealth knew.
And there might be a great
that-
reason, but we don't know right now.
We don't know what it is. No explanation has been made, and the Commonwealth kind of dodged a number of moments where they were going to have to explain the delay.
So you agree with Justice Gaziano that the burden to move for due process dismissal is on the juvenile?
I think that the judge could do it sua sponte.
Okay, but I mean, but in the absence of, but in the absence of any reason to do it, you don't need to do it.
Yeah, that's
But
our
once you need to
position.
do it, then the burden is on the Commonwealth then to prove that there was good reason.
Was that
That's
what you're saying, or are you saying that the burden is on the Commonwealth initially to make a showing?
I'm saying the burden is on the Commonwealth initially to make a showing, and we suggest in the application for the complaint, just set forth a fact or two explaining the delay.
And then
And
if it's
then-
challenged by the defense,
Correct.
then it becomes, again, the Commonwealth's burden to come forward and prove that it was notwithstanding what it
Exactly.
says.
That's exactly our
Can you refresh
suggestion.
my memory on the framework of the parameters of the delay? What would constitute a delay?
Well, there's a delay inherent in any 72A prosecution, because we're talking about a case where at least a year has gone by since the child was under 18, until the child was over 19. So there's always delay. And the question is whether that delay was in bad faith for tactical advantage, or whether it was an inexcusable neglect, or whether it was a justified delay.
So every case that came under 72A would be subject to this.
That's correct. I mean, so that's why our position, our suggestion that the Commonwealth that the application for the complaint, or the initiation of the proceedings set forth an explanation for why the delay in this case would potentially limit the number of motions to dismiss, because if the Commonwealth has a burden to justify the delay in every 72A case, which it does because there's always delay, then why wouldn't there be a motion to dismiss in every 72A case?
The only issue, oh, sorry.
I was going to say, you're talking about the difference between delay and undue delay?
That's correct.
And what is undue delay here, you're saying?
Well, we don't know the reasons for the delay.
I understand that, but how long is the delay here?
Well, the delay is almost 2 years.
All
It was
right,
almost 2
okay.
years from the incident to the initiation of
The first year of
process.
it, you say that's pretty normal. It's the second year that's the problem.
Well, it's always going to be at least a year.
Right, okay, I'm sorry.
This will be the first time we've ever extended this ability to dismiss prior to arraignment when there is probable cause, right? The only issue we've got before us is whether to do this pre-arraignment or post-arraignment, right? So this is the first time we're going to be saying, you got probable cause here, but we're still going to do this prior to arraignment.
Actually, in Mogolinsky 2, I believe it is, or 1, in Mogolinsky, it was a jurisdictional issue. And the case was dismissed on the basis of jurisdiction, even though there was probable cause prior to
So
arraignment.
remind me why there was no jurisdiction there?
It was because of the age of the juvenile. It was Mogolinsky 2, so I think that after the case had gone up and gone back at that point.
But again, that's an age issue, not a, here we have probable cause. This were brought in juvenile court in a timely way that certainly should have been an arraignment. But now that the prosecution's delayed, we're not going to do it. We're going to do it pre-arraignment. I'm just trying to understand the logic of why we create no record here. I understand in Humberto H why we didn't want to create a record, because there was no probable cause of criminal or juvenile delinquent behavior. Here, we have that behavior, but we're going to do it prior to arraignment.
Well, a major part of the reasoning behind Humberto H was to protect the child against the
Well,
consequences.
because the
of being-
child, there was no probable cause to bring any proceeding against the child.
But of course, if there were no jurisdiction due to age or due to, in this case, the improper invocation of this unique jurisdictional statute,
I get why I get why they can't proceed. I get why you punish the Commonwealth for its bad behavior and delay, but I don't get why there's no record created. What's the logic in that?
because it's not, the juvenile shouldn't be saddled with all of the consequences of being brought into the system and having the creation of the curiae and so forth.
Well, he would have
where
been, it
there's
would have been
not-
fine if they did it in juvenile court. Again, you would have had an arraignment in juvenile court because there was probable cause. It wouldn't be an Humberto H case. It's just now, it's like you get it an even better, because the Commonwealth is delayed, now you're, even though there is delinquent behavior, it's completely wiped out. Just seems like we're going one step further than we've gone before.
Well, once upon a time, I mean, that was the way it was in any case where the child aged out. There just was no jurisdiction, there was no case, and the legislature sort of understood that the natural maturation process gave sufficient assurance that that this wouldn't be repeated, and that, you know, nature did the job that the juvenile court would have done. So it's not that outlandish to suggest that in a case where the Commonwealth is trying to manipulate the system in order to invoke 72A, or the Commonwealth has been inexcusably negligent in the initiation of process, that the child sort of doesn't get into, the individual doesn't get hauled into court for the thing that they did when
Well,
they were a child.
I just wonder what step comes first in the analysis, however, when we're talking about jurisdiction. So I'd like you to talk to me a little bit about jurisdiction. Why isn't it that the issue here is whether or not this now 19-year-old should be prosecuted in the Superior Court, whether they should have the jurisdiction? And assuming probable cause, one of the questions as to whether or not there should be a prosecution in the Superior Court is the reason for the delay. Because as you've referenced, there can be all sorts of untoward reasons that might exist, or inexcusable reasons that might exist for the delay. But why isn't the whole 72A transfer process really asking the question of whether there should be jurisdiction in the Superior Court to prosecute this case?
I mean, the question is whether there's jurisdiction at all. And we know that it goes to the Superior Court if there's going to be jurisdiction at all, because the child is an adult. And imagine a scenario where...
Only if it's in the interest of justice to do so, right?
I'm sorry, I just
But it's
didn't
only
hear.
in the interest of justice to do so. It only goes to the Superior Court if it's in the interest of justice to do so, right?
That's correct. And of course, the question of delay is going to come into play there, but it's going to be different than, for example, imagine a case where the Commonwealth deliberately waits because it's not a case that qualifies for youthful offender indictment, and they think it's too serious to stay in juvenile court, and they want, you know, I hate to say that this might ever happen, but imagine that it did. And so the Commonwealth deliberately undertakes to charge this child as an adult and waits the period of time for that to happen. So now the juvenile so this is improper. I mean, it's inappropriate. It's not fair to the child for the consequences of their child misstep, their youthful mistakes, to follow them into adulthood. We have policy against that. So the juvenile bears the consequence of having been arraigned on a juvenile complaint, of having been made to work with counsel to pull together to mount a vigorous defense on probable cause and on the interest of justice. And the juvenile is bearing these consequences, and the only consequence to the prosecution is that potentially the length of the delay plays into the question of whether the prosecution goes forward, when the consequence to the prosecution should be that they're not allowed to institute this prosecution. The juvenile And it should be, out of fundamental fairness, spared that process.
Thank you.
Thank you.
Ms. DeLateur, good morning.
Good morning, Your Honors. May it please the Court, Monica DeLateur on behalf of the Commonwealth. Sitting with me at counsel table is Assistant District Attorney Michelle Slade, who is the trial prosecutor in the underlying case.
Can I ask you a question to begin with?
Excuse me?
I just wanted to be clear about where the Commonwealth's position is.
Yes.
Yeah, it seemed to me that below, the Commonwealth is basically saying, oh, no, this question of whether or not we delayed, that gets resolved in Superior Court. That doesn't get resolved in juvenile court. And it seemed to me that in your brief, you were saying, no, it gets resolved in juvenile court. It just gets resolved in the second prong of the inquiry, of the transfer hearing. Is that right?
Yeah. It is consistent with our previous position. So in our motion to arraign, it's in Commonwealth's Appendix 133. We stated that we believe that the merits of the motion for a prosecution, to dismiss or prosecution delay, should happen at the transfer hearing. It's also consistent with our position in the opposition to the 211-3.
Okay, then is it inconsistent with what the judge did?
To the extent that Justice Craven here held that it should not be considered at the transfer hearing, I would agree that that is incorrect.
Okay, all right, that's the source of it. Okay,
Yes.
thank you.
So you say that the judge should basically decide probable cause, and if there is probable cause, arraign the person,
Correct.
and then determine where the issue is raised or is a live issue, whether there's a due process issue, and then whether in his or her discretion the case should be dismissed or a criminal complaint should issue.
That is
You think
correct.
that should all happen in juvenile court?
That should all, yes, to be clear about where we are, the transfer hearing does occur in juvenile court before any particular transfer to the adult
So
court.
I guess the confusion that I have is why do we proceed with an arraignment where the matter will invariably be dismissed in juvenile court, either because there is a due process violation, or because the matter should be discharged, or because it should go on to be tried in Superior Court? The case can never be tried in juvenile court, so I don't know of any situation in which we arraign somebody where we know it's going to be dismissed.
Well, I think it's unclear if it would be no, it would be dismissed. I think in the absence of statutory authority to do so, a juvenile court judge would not be able to dismiss before arraignment on the grounds in the interests of justice, and indeed doing so would be a violation of separation of powers.
But I guess the question is, the case can't proceed in juvenile court. I mean, the transfer hearing has to say either the case will be dismissed or it will go to Superior Court. So what is the purpose to have an arraignment when the case invariably cannot proceed in juvenile?
Well, there has to be an arraignment before the transfer hearing. The transfer hearing is focused on the offenses that are charged, and there wouldn't be any alleged charges at that point if it had happened before arraignment. So there does need to be an arraignment in juvenile court before the transfer hearing, and that arraignment can occur on a legally valid complaint. So just looking at the four corners of the complaint and determining whether that is a legally valid complaint to go forward. And that can happen in the juvenile court before arraignment.
You're just really talking about the certain parts of an arraignment, a question of whether or not counsel should be appointed, whether or not the juvenile understands the nature of the charges. That's just part of the arraignment process before you move forward.
Correct. So in terms of there being jurisdiction under the statute for the case to go forward, and then whether there is probable cause. Those are the two determinations that can be done before arraignment in the juvenile court. And Newton N confirms that, Orban O, and I would suggest Benjamin B is the other case as well. Like those are the two determinations that a judge can make at that time. And I would suggest in allowing this type of remedy where we could have a motion to dismiss for prosecution delay before arraignment, and I think this is to Justice Kafker's point, where this would be allowing a type of remedy for this particular group of juveniles that wouldn't actually be available for any other types of juveniles. Those are the two determinations that you can have before arraignment that could allow for a dismissal of the case, and this would allow a separate type of remedy that would only be would only be able to happen with this particular type of group.
Understand that. Can you express for me again, what is the harm to the Commonwealth proceeding as the juvenile has suggested?
So I would say there's three considerations. As I've noted, it would be a violation of separation of powers to allow a judge to make that determination to dismiss the case at that point in the interest of justice. It would be a judge stepping.
Is that really what the judge is doing, though? Isn't the judge doing it because it's a violation of due process?
Well, I would suggest, I mean, it's, if you're thinking of in terms of the interest
Let's
of.
say there's a lousy delay, lousy reason for delay. Let's say there's really no good reason for delay. And the judge hears that after having seen in part of the application that the Commonwealth basically has to say what the reason was, right? That's what the defendant is suggesting. That they have to first say, the Commonwealth first has to, with its initiation papers, has to say what the reason was for the delay, right?
I'm sorry, I didn't quite
It
understand.
has to say what the reason was for the delay, right? That would be the first step. With the initiate, according to the defendant, with the procedure that they're asking for, is the first step would be for the Commonwealth in its initiation papers to somehow say, well, this is the reason for the delay. Let's say it's a bad reason for delay. And the judge says, okay, I'm not going to put up with that. It's dismissed. You're saying that's a violation of Article 30?
But yes, I am saying that, because that would allow a judge to determine on a legally valid complaint without statutory.
Why is it a legally valid complaint if it's being brought for a lousy reason for the delay?
Well, there
after
it's,
the delay?
as long, I'm sorry, excuse me.
I'm sorry, I just, I'm assuming the worst. Now, you can see that in the decisions, we did not assume the worst about the Commonwealth. We felt that this was going to happen very rarely, right? We thought it was going to happen very rarely that there would be an abuse of discretion by the prosecutor.
Yes, I would agree that would happen rarely, but in terms of in terms of figuring out jurisdiction for a legally valid complaint, the delay of a prosecution.
How do you determine, I guess my question is, how do you determine it's a legally valid complaint?
So determination of jurisdiction and whether there's probable cause. But under the terms of jurisdiction, it's whether the case can go forward in juvenile court, and the delay of prosecution has nothing to do with the jurisdiction of whether the case can go forward and whether it's a legally valid complaint rooted in probable cause.
So essentially what would happen is we would have a different way of analyzing these cases from adult speedy trial cases. It'd be a whole different way of a whole different framework for analysis.
I would agree with that, and this court has never found that either in juvenile court or in adult court that the actions of the prosecutor were so egregious that it would bar arraignment.
I had
Yes.
asked you to give me the reasons it would be difficult for the Commonwealth or harmful, and you told me one, and then so can you give me the other two?
I'm sorry.
No. So that was the first one. The second one, which I've already iterated as well, which is that it would be allowing for a different treatment for a particular group of juveniles that are charged in this way. And I think it's also important to consider what an evidentiary hearing before arraignment would even look like. I would point again to Newton N, where this court iterated that there may not even be enough information for that type of hearing before an arraignment, and indeed before arraignment, before there's even attachment of a right to counsel. I would also note again that there's no statutory authority, again, to litigate this type of motion. And if this is allowed, I do not see a reason why a defendant would be able to bring any other type of motion before arraignment as
So
well.
along those lines, obviously, we don't just have statutory speedy trial, we have constitutional speedy trial issues in Bancroft v. Wingo. And if the speedy trial provision of the Constitution has been violated, then there's due process concerns about that prosecution. However, are there any cases ever suggesting in any context that where there's a constitutional speedy trial issue that some proceeding has to happen pre-arraignment?
I have not seen that before, no. I would suggest that the way that the legislature has created the juvenile code has provided a mechanism in a 72A transfer hearing for those concerns to be addressed. But no, I have not seen that.
Why wouldn't the statutory authority be found in Section 72A itself, although it doesn't say anything about a pre-arraignment bad faith delay hearing? It could be argued that such a hearing is necessary to effectuate 72A because the legislature has given you this extraordinary authority, as prior counsel had just said, to bring these cases, and now you have this authority. The statute may contemplate having a hearing to find out whether or not that authority has been exceeded.
So I would suggest that it's consistent with those two considerations under 72A in terms of determining whether there has been prosecution delay. It's consistent with the interest of justice and the protection of, the interest of the public and protection of the public. And I would note that the case law under 72A is very broad in what those considerations are. It's guided by fundamental fairness. There are no evidentiary rules that need to be followed. And indeed, that language in terms of interest of the public and protection of the public are interchangeable. And essentially, the question is whether the juvenile should be subject to any prosecution at all.
Are you done? Sorry. Yeah, I'm trying to understand in a case in which you have, I'm not saying this is the case, but in a case in which you have abused the process, the Commonwealth has delayed, improperly. Why do we want this post-arraignment? Why do we want the record? Because what we're creating is, in Humberto H., I understand the whole logic of having no record. Here, we're going to have no record. And is it valuable to have a record in this circumstance? I'm just trying to understand, in a case where the Commonwealth has created a due process violation, why do we still want an arraignment and a record in that respect? Why is that good policy? I'm not saying it's not. I just don't know. I'd like to understand that.
Yeah, I think there would still need to be, if it's a legally valid complaint and that the actions of the juvenile have supported probable cause, that can still result in a carry record. I still think that's appropriate, and not being able to have judges step in terms of when.
So we want a carry record in a case in which there is probable cause to have proceeded in juvenile court, but the Commonwealth created a constitutional due process violation by delaying.
I think without statutory authorization, has to be the procedure going forward. I will note that.
Why does it have to be the procedure? That's one thing I'm not quite sure I follow. Why does it have to be the procedure?
Well, in terms of if the prosecution has decided to go forward, that would be the next step in terms of there being an arraignment and that a carry record would enter. I will note that in the last.
I'm not sure I see how you've sort of lost your high horse in my hypothetical, by behaving improperly. I'm trying to understand why we still want a record of that juvenile. Is that to protect the public, that this person, there was probable cause and we want to know about that? I mean, I'm just trying to understand the logic of keeping a carry record in that case.
Well, I wouldn't suggest that prosecutions go forward on bad faith, but I do think that there would need to be a carry record in terms of it being a legally valid carry record. I think that actually fits in with the purpose of 72A about not having defendants fall in between the cracks of these cases. I will note that if a case does end up being discharged at the 72A transfer hearing, there are now mechanisms in place where a juvenile can expunge and seal their carry record.
Well, shouldn't this be the extraordinary case? We assume that you're going to act in good faith. This should be the extraordinary case. That's what the footnote had contemplated.
Well, I think so.
I would hope so.
Right. The footnote in Mogolinsky 1 and the iteration in Mogolinsky 2, the Commonwealth is not suggesting that there is not a burden, that they have to show that there is inexcusable delay or there is an absence.
I might agree with you that the juvenile should be the moving party in this, but once the issue is raised and a judge finds his bad faith, I think the point that Justice Kafker raises is a good one. Why should the juvenile be saddled with a carry injury?
I think that in this current legislative scheme, that is the procedure going forward, is that if it's supported by probable cause and if there's jurisdiction under the juvenile code to do so, it would proceed with the arraignment and a carry record.
Well, why isn't the answer to the question, well, Article 30, there's probable cause, arraignment. At the transfer hearing, there's a determination of bad faith, and then there's a motion to expunge because it was a due process violation and there shouldn't be anything on the carry. And you don't have anything on the carry, but you don't have to violate Article 30 to get there.
I would agree with that. That would be that would be the procedure. Is that?
Go ahead. Would the next step, or would it be possible if there was an allegation that the police in some way had behaved improperly to file a motion to suppress pre-arraignment?
That would not be possible, no.
At all?
No. It would have to, the only two determinations that can come before arraignment are related to probable cause and jurisdiction, related to the legally valid complaint.
Here's my problem. Do we ever have a situation where a court is acting on something that doesn't, that the jurisdiction of the court is not assumed? I mean, in the juvenile court under the Humberto H. Sort of procedure, nobody's questioning the juvenile court has jurisdiction over the matter, right?
Correct, though that situation with Mogilinski 2 would be a situation where there was a question about jurisdiction before arraignment in terms of whether the juvenile had been apprehended after the age of 19, and then also in Wallace W., which was a case from last year, determining Section 52 and the definition of first offense. So those are cases that have occurred before arraignment in that
Okay.
type of regard.
Okay.
So, but I mean, but the difference between this case and Umberto and Orban and Newton is that the statute provides for the possibility of a juvenile court judge having the authority to dismiss the case, which you don't have except in 72A.
I see my time's expired, but if I may answer the question.
Yes, go ahead.
Yes, I would agree with that this legislature has provided this as a mechanism.
Okay, so I mean, it seems that the issue of query is not so much an Article 30 issue, because the judge here has the statutory authority to do what a juvenile court judge would not do in other circumstances, but it's a question, it's a prudential question of whether a finding of probable cause should trigger a carry.
Yes, a carry, not a query, I just want to be clear.
Carry,
Carry
I-
record,
right.
yes.
But in the statute, correct me if I'm wrong, it says discharge, not dismiss, correct?
It is just, yes, it's discharge or it's dismissal of the juvenile complaint
Right.
to issue a criminal complaint. I
Right.
apologize that I was using those terms
Right, so
interchangeably.
the discharge seems to me to be something that should not trigger a carry, correct? I mean, because in some ways, and the defendant, the juvenile may disagree with this, the Commonwealth should be incentivized not to bring these because it could lead to an ultimate discharge.
Yes, I would agree
Under
with
the interest of justice, and the juvenile court just say, you have probable cause, but I'm looking at this thing and given the passage of time, the gravity of the offense, et cetera, matter's discharged.
I would agree with that. That happens to be a disincentive for the Commonwealth to delay, is that there is the safety valve essentially in place to ensure that only proper cases can go forward. Excuse me. And I would note that in Newton, and it was partly deciphered that that this could result in an entry on a carry, but without the legislature acting and providing this authority, it would be a violation of separation of powers to dismiss a legally valid complaint.
Okay, thank you.
All right, thank you very much, Your Honors.